Okay, so for the 6th time, gonna record this video because I think it's important. And it didn't start out as this kind of video. I intended it originally just to be a quick off-the-cuff kind of, hey, let's record the verdict for historical value, I guess. I don't know, just whatever. And I saw something in the trial that it changed all that. I was like, oh my God. So I decided I had to make a video, show everybody what I saw, because I thought they'd get something out of it, learn something, think it was interesting, something. And I'm going to make sure this is recording right now. Looks like everything's working, finally. So, yay. Anyway, so a little bit about me. I did digital forensics for a couple years. I had my FAA Part 107 drone license for a while. I've worked in IT for a decade, a little over. And I've been a photographer and videographer for years and years and years. That's why when I saw the drone video and how it was handled, I couldn't believe what I was watching. So the drone video was a video that showed up after the trial had already started and was supposedly provided by an anonymous source. The entire time I was looking at this like, why is this being admitted into evidence? I don't get it. They even had the judge come down and sit like 5 feet from the TV as the fat prosecutor was up there with like a ruler or something, like, see, this is where it's happening. And he didn't see it. No one saw it. No one knew what anyone was talking about as far as this video goes. What the prosecution was trying to do is they were trying to say that, oh, look, in this video, it shows Kyle raising his weapon and it provoked the pedo dude, Rosenbaum. It provoked him to attack. They never alleged that he pointed it at Rosenbaum. So I guess him pointing it at somebody else supposedly made Rosenbaum freak out. I don't know. It didn't make any sense. It probably never will make any sense, but that's what they were going for. And no one could see anything in the video anyway. So the whole time I'm looking at this like, why is this being admitted as evidence? And the judge seemed to have this kind of, well, we'll let the jury decide kind of approach, which when you let them see bad evidence, that's kind of not a good thing. It's more on the lawyers. It's kind of the lawyers' jobs to be the guardians of the evidence.
One of the functions, a core function of a court, is to act as a gatekeeper on the evidence and the legal arguments that can be used to arrive at a verdict. So we all know that there's evidence that's excluded. That's happened in this case, of course. There's also legal arguments that are excluded, and there's also legal terms of art that are applied in very specific ways in the law that they're common terms, but they mean different things when you use them in a common way than when you use them in a legal sense, especially in this case, this word provocation. In general use of the word provocation, it's kind of amorphous. Lots of things can be provocative. In the legal use of force sense, as used in this case, provocation means something that leads to an immediate forcible response and nothing else. So Kyle carrying the rifle is not, it may be provocation in a colloquial sense, I guess one could argue, but it's not provocation in a use of force sense, because that's not what led to an immediate forcible response. So we don't want people going home and looking up dictionary definitions of words that may be accurate in a non-legal sense, but are extremely misleading in a technical legal sense, and therefore lead to an unjust verdict.
But regardless, this never should have been admitted as evidence, period, at all, ever. But then things got really crazy. Fat boy over on the left is going to basically try to throw somebody else under the bus, Miss Wisco, who is the defense's, I'm not sure what she is. I haven't looked. I'm not looking now. I don't know. But he's going to try to blame her for all that. Well, you'll see. I'll stop periodically and talk and explain what's going on and why it's relevant and so on and so forth. I'm also going to edit pieces out because there's chunks that don't matter. I'm putting links to everything in the description. If you want to watch the full thing, have at it. Go for it. But yeah, so here we go.
All that.
If I can respond at least to that portion of the motion to dismiss.
The motion to dismiss was filed by the defense, obviously, partly because of this evidence. Not entirely. There was a bunch of shit in this trial that was just super sketch, but this the drone video was a big part of it.
It's it's factually inaccurate. So let me go back to the first Friday of trial. Mr. Lukowski was testifying. In the middle of his testimony, I got a notification that there was someone at our office who was refusing to give his name with a drone video. This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video. We've been told since then by the person who took the footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted.
The poor quality video is the video. That's the original video that was provided, and you'll see how we know that shortly.
On Friday, the individual who took the footage, who had been unable to find, came and airdropped the footage to Detective Howard.
Okay, airdrop. What? Airdrop? That's how we transfer evidence? What? That's when my ears kind of perked up. I was listening to this and I was like, wait, hold on. You guys are transferring evidentiary files and stuff via airdrop? What? Oh, but wait, it gets better.
Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email. It has to be iPhone to iPhone. Detective Howard asked them how they would like to receive it. Ms. Wisco asked that it be emailed to her. He emailed her the file.
So now they're just willy-nilly emailing videos around, apparently, which, again, is not how you handle evidence, but okay, we're going to keep rolling.
Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to an Android, it appears somehow compressed the file.
So not only did Fat Boy here just contradict himself, he's like, oh, well, couldn't do an airdrop because she has an Android instead of an iPhone. And then he says, this guy, I swear. But he's going to, watch, he's going to try to throw her under the bus and she's going to step all over his genitals.
If I knew how to compress files and knew all this technology things, I'd have a much better job.
Don't you think maybe you should know enough to do your job effectively there, fatty?
So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone.
We couldn't be responsible for the software on... Wait, watch. He's gonna try to throw her under the bus so hard, little sniveling fat bastard. Watch. What a piece of shit.
It was we didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy. And until Friday, when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time.
Gmail. Now not only are we airdropping evidence, we're using Gmail for evidence. Really?
It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had. and then I put it on a thumb drive to give to the state crime lab. So I cannot explain why Ms. Wisco's file had been compressed.
It wasn't compressed.
That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file.
No, it didn't. And I'll explain why. I'll explain how we know that. Hold on. Because we haven't gotten to Ms. Wisco yet.
The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file.
None of us know how to... It wasn't us. What a piece of shit.
We wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski's being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and...
It wasn't compressed. You see what he's doing, though? He's putting that out there. He's putting that out in the ether. It was compressed. We don't know what happened. We don't know why. It wasn't us. I don't think that's what happened at all. I'm pretty damn sure that's not what happened at all. And regardless, I got major problems with this far beyond that. We'll get to that in a second.
Somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well, we had a bad copy, they could have checked, they could have asked for a thumb drive, they could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
The prosecutors here are literally the living physical embodiment of why everybody hates lawyers. Right here. This disgusting, shady shit. Right here.
Well, why don't you start, Ms. Wisco?
Can you talk into a microphone? Yes. On November 5th, 2021.
So let me go back to the first Friday of trial.
On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video that was titled IMG_0159.MOV.
So she got a 4 meg millibyte. That's funny. She got a 4 meg file, which it looks like she's using Outlook, and it probably rounded up. It's 3.6 megs. That's the original file. That's the real file. And I have 2 possible explanations for all that. But again, I'll get to all that.
I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using through the duration of this trial.
What manufacturer is that?
This is a Lenovo.
Not that it matters anyway. I mean, playing a video doesn't change the file. Generally speaking, if you open whatever in like VLC or something, it's not going to alter the video. Like that's not, it's still going to be the same file size, still going to be the same resolution. It doesn't.
I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the videos being shown, and for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in.
Yeah, just gonna put that out there for good measure.
However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. ADA Krause was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and ADA Krause, and I asked for an exact forensic copy of what they had given to the state crime lab.
Exact forensic copy. You hear how she said that, right? Very important.
ADA Krause responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.MOV that was a 4 megabyte file. Simultaneously, ADA Binger had been in contact with me, told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4.
See, she's doing her job. She's at least one step closer. I got other issues with all this, even on their part, but at least it's closer. So, okay, good. Verify. She checked. She's like, no, I want to see what I'm picking up. I want to make sure it's the right damn thing. Good on you.
So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When ADA Krause followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 megabyte file that I had gotten previously.
So clearly Attorney Wisco's email is compressing these files. That's not our responsibility. Oh, I didn't write Outlook software.
You know what?
I forwarded
But wait a minute, I don't know if she had finished.
No. Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have.
Now, Dropbox could actually be used in a forensic setting. You can hash things. You can verify chain of custody. I'll get into all that stuff in a second. Dropbox, I could at least see being usable. That's fine. But email and AirDrop? What?
The file title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy.
So at least the name had to have been altered, although we know it's been changed a whole lot more than that because it's tripled in size. More than tripled in size. And this is supposed to be evidence in a murder case where a kid's life is on the line. Yeah. So I'm not going to go any further in this. Again, the links are below if you want to watch it. The main issues that I have with this, shall we? Time to put my forensic hat on. So it's a forensic hat time. Here we go. I got the forensic hat on. When you're doing forensic data collection, the correct way to do it is, say you're picking up a desktop from somebody or something, the suspect. You're seizing evidence, right? First thing you do before you do anything is you take pictures of everything. You document everything, right? Then you take the desktop or whatever it is, and you pull out the media, the drive, and you put it in what's called a write blocker. Write blocker, as the name would kind of suggest, prevents writes to the disk. So you cannot change the data on the disk. You cannot physically alter, like literally the ones and zeros on the drive. You can't. You make a forensic image of the drive. When you do that, you create a hash. The hash is used to verify file integrity. So you can always tell this file, this hash, you put them together and you're like, okay, this file hasn't changed. It's called data integrity, which these fuckwads apparently give zero shits about. This is what blew my mind. They're going through all this with the drone video, never mentioning chain of custody, documents, never mentioning images or hashes or anything regarding file integrity. And I'm telling you, I would give them the benefit of the doubt, say, oh, well, you know, they probably did it. They're just not mentioning it. But if they had done it, they'd have been whipping out that paperwork so fast. This is where it came from. This is where it went. This is what happened. Everything. They'd have whipped that shit out right away, but they didn't. So after you do the forensic image, that's what you're actually doing the analysis on. That's what you're actually looking at and manipulating. You never touch the original data at all. The original files and all that never get touched. They never get altered. They never get changed. You're always working on copies of data. And you get this guy who is emailing shit from his, later on he says, his personal laptop at home because it was a Saturday. He actually says the dude emails him the file and he's at home in his personal Gmail account and he puts it on a thumb drive at home. I couldn't believe what I was hearing. I could not believe it. Anyone, anywhere could have done anything to that file. Like, this is a damn murder trial. What is this guy doing? Couldn't believe what I was hearing. I'm going to show you the drone video now. I can't verify this source 100%. I believe it to be accurate, but I mean, how the hell do you verify something like this? I don't know. If you want to believe it, believe it. If not, cool. I don't care. Either way. But this is the video that they showed in the courtroom. I did see that. And the quality and the numbers and everything makes sense. And I mean, it all adds up. It all makes sense. So, you know, Occam's razor, people. Let's go with it, huh? On the top, you have the video that was given to the defense, 480 by 212, 3.6 megabytes, right? On the bottom, you have the prosecution's one, the one that they tried to pass off as evidence, 1920 by 844, 11.2 megabytes, grown by over 3 times in size. And the issue with that is that when, in a case like this, where your entire case hinges upon, well, he raised a gun, you have to be able to see that. You have to be able to prove that. When you sharpen and enlarge a file like this, a video like this, be it an image or a video, you're adding data to it. Hence the discrepancy in the file size. You can't make something out of nothing. You have to fill it with something. When you make an image bigger, you have to put something in there or it's just going to get pixelated and look like ass. That's why you can enhance stuff and you can make it look sharper and you can make it bigger, but the processing and the what's going on behind the scenes, you have to be able to prove. And especially in a case like this where you're talking about something that took place on a screen supposedly and it's this big and it's, I mean, no. I mean, maybe what you're looking at was added by the computer. Who the hell knows? Maybe it's not there at all. Who knows? You have no way of proving. You may know, you may think you know, but you have to be able to prove it. And that's what they could not do with this evidence. This should have never been admitted, ever. And I really think that if they had come back with a guilty verdict somehow, some way, I really think the judge would have canked it. I really think he'd have been like, nope, dismissed. Stuff like this and all the other crap that happened in the I'm not going to go into everything that happened in this trial that really had me scratching my head, especially as I was watching with a bunch of lawyers, for God's sake. Like, everybody was like, what is going on here? Very strange things happening, but this was the main thing that really caught my eye because I've done this kind of stuff before. Not in a damn murder trial, but, you know, I've done data collection and preservation and all that kind of stuff. Done chain of custody, all that kind of shit. I didn't hear them say a word about any of it. Absolutely mind-blowing. But yeah, so this is the video, and you can see the top one looks like shit. The bottom one looks better. Amazing, huh? And supposedly what they're talking about is at the beginning, supposedly he raised his gun to somebody somewhere, and that provoked the chomo to chase him. Even in the enhanced one, I'm not seeing it. And the judge was the same way. He was like, I'm not seeing it. In a legal sense, provocation is different than in just day-to-day use. You can be provocative and you can provoke someone without it being the same as in a legal sense of provocation.
Provocation used in this specific use of force law context is not provocation as we normally use the word, kind of a generally provocative kind of conduct. It's only provocation. An act is only provocation for use of force purposes if it immediately results in a forcible reaction. If it doesn't do that, because in this context, we're using provocation to explain away the forcible reaction, right? To explain why it occurred. If there's no immediately forcible reaction, it's not provocation for use of force law purposes, which is supposed to be the limited context here. So Kyle walking around with an AR-15 is not provocation for a use of force law purposes, because that's not what provoked Rosenbaum's attack.
And it's not
he was carrying a gun all night. Lots of people were carrying guns all night. Nobody else was suddenly subject to an immediate forcible response. So that's not provocation in the use of force context. But of course, the prosecution, having nothing really to work with, is trying to suggest to the jury that anything that they would find provocative or scary or whatever the case might be would be sufficient to strip Kyle Rittenhouse of self-defense. The only provocation that strips you of self-defense is a provocation that's an unlawful act that reasonably results in an immediate forcible response.
And might as well let them explain the elements of self-defense while we're at it.
The core self-defense justification for each count is so strong. I mean, it's a very straightforward analysis, right? There's only 4 elements under Wisconsin law. Was Kyle the initial physical aggressor in that confrontation? The answer is no. For everyone, he's being pursued, he's being chased, force is being inflicted upon him as he's fleeing. Was the threat he was facing imminent? It was in progress. That's imminent. It's actually happening. Was he facing a reasonably perceived risk of death or serious bodily injury? In every single one of those, he was. Even jump kick man, boots to the face, is serious bodily injury. That's the only one I can imagine even being a close call. Certainly a skateboard to the head, the gun. If someone's fighting you for your gun, they're arming themselves with a rifle. That's deadly force. Yep. And then the final element is just, did he perceive these things reasonably? Did he imagine a gun? Did he speculate about a threat? None of that happened here. We can all see in the video it's a reasonable perception of events, although the use of force expert would, of course, be helpful there. And with those 4 elements solidly locked in for each of these counts, you don't even need to get to the criminal counts. I mean, it's just self-defense. You're done. You go home for lunch.
The defense super epic failed by letting this get into evidence, because this, not only is it just, I'm not seeing it, no one was seeing it, but the entire circumstances around the evidence itself is garbage. Garbage. Remember, it's not a preponderance of the evidence like for civil shit or whatever. It's beyond a shadow of a doubt. You have to be 99.999,110,000% sure that what the prosecution is saying happened. If this garbage in one way or another doesn't raise a shadow of a doubt in your mind, I can't help you. I mean, you can hate Kyle if you want. You can hate the judge. You can hate the whatever. It doesn't matter. It doesn't change anything. When you look at the evidence and you look at the charges, it just ain't there. It was the most cut and dry self-defense case in the history of like mankind to begin with. But then you get garbage like that. I couldn't believe what I was watching. I couldn't believe it. Epic mishandling of evidence. Couldn't believe that shit. But yeah, so for those of you that don't know, in my Herculean efforts to get this damn video made over the past 3 days, the verdict came back and he was found not guilty on all charges. So rightfully so. Yep, we're doing this like this. True. Yep, true story. Because now my camera died. I swear. The gods do not want this video made, I guess. I don't know. It makes no sense, but this is how we're doing it. This is what's up. Like I was saying, he was found innocent, not guilty on all charges, and everything's done and over with. The kid can get back to his life. Thank God. I feel bad for the people in Kenosha now because I am sure the city is going to burn. It's awful, but, you know, yeah, I mean, what can we do about it? Maybe have some more Kyles may help, but maybe that'll provoke them. So stupid. Anyway, yeah, any questions or any stuff like that, be sure to leave them down below. Please, dear God, give this video a like. It was such a pain in the dick to make. That's how it goes sometimes. If I'm going to start doing videos like this more often, I really need to get a different camera because this thing's a pain in my ass. Kind of repurposed my old A6300 and it's not happy about it. Anyway, till next time. Later.